So we are now live on YouTube. Judge Holmes is going to begin shortly. Thank you. Yes, sir, Mr. Junior. So basically, what's going to happen is when Judge Holmes comes on, she'll call the cases in order. As you see, there's a lot of faces on, and so basically, we'll just call the cases in the order in which she calls them and hear one case at a time.
Good afternoon, everyone. I'm Judge Holmes. Give me a thumbs up so I know that my audio is coming through nice and clear for everyone, if you don't mind, please. Okay, looking good. Thank you very much, then. We have several matters on the docket. A couple of them sounds like they've already resolved themselves, though. And so I think I heard for cause 23-001400, that's Alinsco Insurance, the subrogee of Escobedo versus Kyle Striegel. On behalf of Alinsco,
Right here,
Ms.
Carolyn.
Nowak.
Yeah.
Good afternoon, Ms. Nowak. And on behalf of Striegel, Mr. Lopez, are you counsel for that?
Yes, ma'am. Yes, Your
Good
Honor.
afternoon. Oh, you're both fine. All right, Ms. Nowak, Mr. Lopez, my understanding, I heard from Brochet that there was an agreed to continuance on this one.
Yes, Your Honor.
All right, any typical timeline that y'all are looking for?
60 days?
Yep, that sounds great.
Okay.
Well, court is happy to grant or approve, rather, since both of y'all agreed, right? I'm not pushing it forward. So agreed motion of continuance for at least 60 days is granted. Do y'all need anything from the court today?
So thank you. Will you just send us a new notice?
Yes, we will.
All right. Thank you very much.
All right, then if there's nothing else, Mr. Lopez, Ms. Nowak, all parties are excused.
All right. Thank you.
Thank y'all. Have a good afternoon.
Bye.
All right. And then we have one default matter and one contested hearing. So we'll take care of the default first. The time is now 2:08, so we're calling forward cause CV 24-001364. This is Barrett Drevno and Matthew Drevno versus Cynthia Nolan Wills. Do I have someone here on behalf of Barrett Drevno and Matthew Drevno? You're on mute, sir. You don't need to unmute yourself. Press *6 or in the lower left-hand corner.
I'm Matthew.
Good afternoon.
Hello.
Thank you both for being here. All right. And do we have anyone at all on behalf of Cynthia Nolan Wills? Cynthia Nolan Wills, last call for defendant.
Your Honor,
yes.
We do have the defendant trying to get in. There seems to have been we got a clerk working on it. She's trying to log in and having some difficulties.
Okay, we gave her the phone number.
We did.
All right, we'll tell you what then, since we had set that as a default and the defendant is making an appearance, Mr. and Mr. Drevno, when that defendant arrives, we'll take some information from them and then we'll hear that case second because it would be an older case on the docket then.
Okay.
All right, so you can place yourselves back on mute. We'll give the defendant Nolan Wills a chance to appear. If for any reason they don't appear by the end of the docket, we'll evaluate then what steps to take. Okay. All right, just please don't go anywhere. You can definitely put yourself back on mute, though. All right.
Thank you.
Shay, I'm gonna mark 1364 as a recall, defendant having trouble arriving. But defendant has appeared.
Correct, Your Honor. There seems to be some issues even with Mr. Matthew and Mr. Barrett. There was an issue with their Zoom link for whatever reason. The numbers, I even had issues logging in, so I don't know what happened,
How about the
but we
phone
got it
number to
situated.
dial in?
Right. They can do the Houston number. She's a clerk's working with her right now.
Okay, well, we'll give it a chance then. We'll go ahead and move to the next one.
We
All right.
we were given a different number to get logged in because we called as well, having the
No,
same
that's what I was
issue.
saying. Yeah, that's what I was saying. I was
Okay.
saying the clerk already spoke with you guys and gave you the correct number.
Okay.
And so, yeah, now the defendant's also joining us.
Okay.
Okay, so again, 1364 is on recall. We're going to move forward with the older case on the docket that is ready to go forward. And so this is going to be 24120. So 24-1210. This is William Grody Jr. versus NetSync on behalf of the plaintiff. Do you have someone here on behalf of the plaintiff?
Yes, ma'am, that would be me. Sorry.
Oh, that's okay. Good afternoon, sir.
Good afternoon.
Do I have someone here on behalf of NetSync, defendant NetSync?
Yes, Your Honor. Sarah Sherman with the Norris Firm PC as counsel for NetSync Network Solutions, Inc. I also have with me Mr. Len Noble as corporate representative and Ms. Nicole Nordhaugen as general counsel.
And I'm sorry, what was general counsel's last name?
Nordhaugen. And I know how to spell it, but correct me if I'm wrong. Nord, D as in dog, HOU, G as in George, EN.
That is correct. And impressive.
I didn't do too bad. I put an A instead of an O.
It's okay. I've been married like 20 years and I think my mom still does that. So
All right. Well, good afternoon to everyone. Thank you for being here. All right. Sir, how do I pronounce your last name? Grote? Grote?
You got it right. It's Brody. Thank you.
Grody. Fantastic. All right. Well, good afternoon, sir. This is your case, so I'll just give you a little bit of information and then we will get started with it. I'm assuming parties are ready to proceed? No settlement?
Yes, Your Honor, we are ready to proceed. There's been no settlement.
All right, then, Mr. Grody, you're the plaintiff, which means that you'll get to start and end the lawsuit today. So you'll get to give an opening statement first and you get to give a closing statement last, right? So as the plaintiff, it's your case. And so we let you, well, the law says that you'll go first. And typically what I'm interested in the beginning is just tell me, are you suing the defendant for money or property? And if so, how much money? And if it's property, what specific property that you're looking to get the value of again? Okay. And then you give me kind of just a very general, is this because there was a contract that was breached? This is because someone was a tort, that they were negligent and acted against you? What's kind of the theory of why you're suing the defendant? And then after you give me that basic information, which is an opening statement, defense counsel, of course, you can make an opening statement. You can also wait until the end of plaintiff's case. And then Mr. Grody, I would swear you in and you can begin with your case. You can testify on your behalf. You can call witnesses. You can present evidence. And after you're done with your side, defense will get a chance to what's called cross-examine you. You'll always get a chance to sort of speak one more time, and then we'll move forward back in that method. Okay?
Yes, ma'am.
All right, then. Why don't you tell me, sir, why are we here? What is the reason that you're suing the defendant? What are you seeking?
Yes, ma'am. I am suing the company for final payments. It would have been the month of April 2023's final salary, the amount of $8,333. And then the final, my compensation package consisted of a monthly salary and then a quarterly MOU, memorandum of understanding payment. And that would have been for the months of February, March, and April, since I gave my notice to my supervisor on the call here, Lynn, that my last day of employment would be April 30th of 2023. And the amount was $20,833 total, the $8,333 that I mentioned, and then the $12,500, which was the quarterly MOU, that were 4 payments of that for $50,000 a year. The court had a limitation of $20,000. So when I filed the claim, I opted to just set the claim at 20,000 flat and negate the 8,000 or 833 dollars that were left on there. So that's the amount, and it's just the final payments of compensation.
All right, Ms. Sherman, would defense like to make an opening statement?
Yes, Your Honor, just very briefly. So as you know, this is a breach of contract case. I don't believe that it is a very highly contested case. I think this just comes down to the unfortunate situation in which the parties to the contract ultimately found out that the relationship wasn't as successful as the parties had intended it to be. And so the dispute is going to boil down to whether there was a legal obligation under the contract to pay for services provided, and whether what services were provided, and whether there were services provided. And NetSync has asserted a counterclaim for essentially prior breach of contract. But however, we are not here to cast aspersions or to allege any wrongdoing. Again, it's just, the unfortunate reality that the relationship was not successful and it did not turn out the way everybody had hoped it to turn out.
All right, and specifically, what is the counterclaim claiming and what do you want? Or what is being sought?
Well, again, Your Honor, so as you know, the jurisdictional limits are capped at the 20,000. We do have attorney's fees. Over the period of the contract, Mr. Grote was paid about $244,000. He was given about $50,000 in the MOUs. And so, and then we have about $4,000 in recoverable attorney's fees based on the counterclaim. And so we would just cap it at the $20,000 based on overpayments of the MOUs as well as the attorney's fees.
Ms. Sherman, I'm still not understanding. So the counterclaim is for
overpayments under the contract for the memorandum of understanding, which were
defendant says they paid the plaintiff 2 months, plaintiff should give him some money back.
yes.
Okay. What's the amount of the overpayments the defendant alleges or counter plaintiff is alleging to the counter defendant?
It would be upwards of 50,000 based on the payment of the 50,000. However, because of the jurisdictional limits, we chose not to destroy the jurisdiction of the court, and we will say that it's capped at the 20,000.
That's not permissible, y'all. So here's an issue that I see for both plaintiff and the defendant. I recognize that it sounds easy to just say we'll only accept $20,000, but state law says that's considered a cram down and that I shouldn't hear either case. That you can't back your way into justice court because you're willing to take less. If your actual damages are truly in excess of $20,000, you got to file it in a higher court. You can't come to me and get around that. So now, Mr. Grote, I don't know. He's right on the cusp there. It may be that he doesn't actually prove that up and therefore he's within it. But for y'all's counterclaim, you can't just bring attorney's fees.
Mm-hmm.
So that would pretty much be, on its face, it would be something I can't hear to begin with.
Yes, sure. You can still hear the prior material breach defense, however.
Sure, your defense is your defense,
Yes.
right? But in
Mhm.
terms of, and if the contract upon which the plaintiff sues says whoever disputes it winds up with attorney's fees, that may get you there if you're successful in the end. But the overpayment portion of it and just wanting to seek attorney's fees on the overpayment, that's not something I could give you.
Understood, Your Honor.
All right. But that gives me a sense. So this was a business relationship between the parties.
Yes, Your Honor.
All right. Fantastic then. All right. Let me go ahead and swear in everyone. Mr. Grote, for yourself, and then Ms. Sherman, I don't know who you intend to call, if that's going to be Mr. Noble or Ms. Nordhaugen, but if we think there's going to be testimony from everyone, if we'll just go ahead and have the witnesses raise their right hand.
It'll just be Mr. Noble.
Mr. Noble. Okay, then Mr. Noble, if you'll raise your right hand. Do you understand that by appearing in court today and offering testimony, you're swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Do you so swear?
I do.
I do.
All right, fantastic. All right then, Mr. Grody, why don't you tell me what this stems from? So give me first real quick, when did you first begin the relationship or working with or for the defendant?
Yes, ma'am. I started working on August 1st of 2023 with NetSync, and came to an agreement and worked with them until, as I stated, April 30th was the last day of notice that I gave to them. And
And
I'm sorry, go ahead.
April 30th of this year, 2024?
Yes, ma'am. About 18 months roughly, or 16 months.
All right. And was there a written agreement between yourself and the defendant about the way you're going to be paid and the timeline for anything?
Yes, ma'am. There is an agreement. There's a subcontractor's agreement that I submitted to you and the court. It's called subcontract agreement. And that was created probably around, I'm looking at the date right now. The negotiations kind of started in July, but by the time we got the agreement ironed out, it was the 1st of August that we signed on and put the agreement into place.
Right. And so you said earlier in your original statement, your opening, you said that you were seeking compensation and payments under an MOU.
Yes, so my compensation package consisted of a base salary of $100,000 a year, or $83.33 per month. And then year one, the company had a memorandum of understanding with one of their partners that funded $50,000 additional to make my total compensation package $150,000 a year. And that $50,000 was broken out into 4 quarterly payments of $12,500 every 3 months.
Okay. So let's start with the base salary. You're wanting to receive a month of salary, the $83.33, and for what month is that? You said
April of 2024.
All right. Was the agreement that you would be paid in advance of work, or you paid the following month?
It's after. It was at the end of the month, and you also have a documentation piece in there that I'm pretty meticulous about logging when I would submit my monthly invoices to them, when they were actually approved, and then when they actually got put into my account via an ACH. So
Okay.
they were always in hindsight in arrears.
So the $83.33 that you're seeking for April, was that work that you performed from April 1st to April 30th, or is that work that was performed in March?
Okay, but it would have been the April 1st through April 30th.
Okay. Were you expecting to be paid immediately, or was there a timeline where you were like, well, I'll give them, they get until the end of May, or they have until middle of June? Was there any expectation of time for that payment?
Just, I guess, the normal expectation of being paid, on or around within the first 10 days of the month. Usually, as you look at that payment history log, there were some instances of some delayed payments in there, but as a general rule, payment was usually within about the first 10 days of the month.
Okay. And did you work under your agreement? What do you have to do to earn the $83.33?
So my position was a kind of a conduit for the company to leverage my previous contacts. I retired from the state of Texas after 28 years of service, and I was pretty well connected after working at 4 different agencies and serving on some boards. And NetSync had wanted to extend or increase their business in state agencies as a whole, but specifically 7 they spelled out, but my contract was not limited to those 7. And so it was my position to do business development to kind of get them meetings and appointments that they had been unsuccessful getting in the past. They would send an email to an official at an agency and wouldn't get a response. I would leverage my connections and positions to get those meetings so that the company could try to get business out of that.
Mr. Grody, what I'm asking though is, were you to be paid you had to do 40 hours a week, or you had to do 3 number of jobs? How would you know when you had done your work per the terms of the contract?
That's actually a pretty intuitive question, Judge. There was a reference to a task order in my agreement that I have never seen one of those filled out, but in my subcontract agreement, it references that as we go through that we would spell out in a task order, yeah, I guess these deliverables. But as it worked out currently, I would make connections. We would say, hey, we want to reach out agency X, and I would do whatever. I mean, I would work after hours, during day, nights, evenings, weekends, whatever I had to use my connections to get these meetings set up. And then we would meet with those individuals and try to take it from there to build a relationship and grow the business.
Was there any hourly expectation? Or is it just we're looking for a certain type of work product? Or is it you have to do 40 hours, and in that 40 hours, we expect that you'll do these types of things?
Gotcha. I think it was more of a work product, an outcome of work product of, positive meetings, getting those meetings set.
I'm going to share my screen, and you tell me if you recognize this document. This was actually something submitted by the defendant, but it says subcontractor agreement. And so is this the agreement between the parties about the work to be performed by the plaintiff or the defendant?
Yeah, there's down at the bottom. Yes, that is.
Okay, so this is the agreement between the parties about work to be performed.
Yes, ma'am.
So agreement between NetSeek and contractor. Services described on the task order. Each task order will be consecutively numbered and attached. The description of services, list of deliverables, delivery date. So things that we're expecting you to do and the date by which they need to be done, how we're going to figure out compensation, and then anything else y'all might have agreed to. Okay. Independent contractor. Contractor must give a written, detailed invoice each month. NetSync will not reimburse for any expenses not approved in advance. Contractor to maintain complete, accurate books and records in order to substantiate any charges or expenses. NetSync agreed to pay the sales, use, excise taxes on performances of things, but not responsible for taxes of net income. A work for hire. Confidentiality. Term. Commences on the effective date. Continues until either party initiates the termination. Otherwise, it's in full force. You can terminate it by giving prior or written notice, but no less than 7 days from such notice, and by paying the contractor all sums due for work actually performed under a particular task order up until the date of termination, including a pro rata portion of the next scheduled payment for any partially completed services determined on a percentage of completion basis or as outlined in the task order. Ooh. So here's where we're going to be looking, right? Section 7.2, payment terms and termination. It really kind of goes together, right? If the contract comes to an end, how do we pay you out? And the other section about payment terms was section 4. Assignment, force majeure. All right, so Mr. Grody, when you entered into the contract, it's dated July 25th, and I can see that it says there's going to be this task order that's going to be attached. And so this one has the date on it at the bottom. Well, it's actually dated October 2021, but I can see that it was dated by you on the 25th of July and by Ms. Nordhagen on the 25th as well of 2022. So is this the first task order that was given between the parties?
I'm not sure I would consider this a task order. It was my subcontract agreement, but I'm not sure how the company sees that, but there was never anything
And it
provided.
says task order on
afterwards.
it.
Gotcha. So then I guess that
Okay.
this would be, yes.
Because it says, this is going to be related to task orders. And so then attached to it is, here's the work we want you to do to get started. And so this is the first one that was created between the parties.
Yes, ma'am.
Okay. And then this one, is this the task order on which you're seeking payment?
We might as well, for sake of argument, we could. I mean, out of the companies that are listed on there, 5 of the 7 we had meetings and opportunities with. So I don't know that I understand that there's a breach other than there's 2 companies or 2 agencies on here that we were not successful getting meetings with, but the rest we did.
Well, right. This doesn't tell me that you're going to be paid in a flat way. It says instead that you're going to be paid per the task order. Because nothing in this first 3 pages here tells me what you're going to be paid. It says that we'll pay you per the task order. But I don't see anything in here about a flat fee of $833 a month. And then the task order attached to it says it began August 1st of 2022, that you were to be paid in monthly installments equivalent to $100,000. And
That's
then
the 8333, right?
okay. So it's in the task order that we get into it. All right. So the first task order, it's $100,000 annually. And then this one here, $50,000 based on the below accounts to be authorized and paid on a quarterly basis. And so, Mr. Grody, you're saying that you're seeking the monthly percentage or the monthly installment for this $100,000, and then some portion of this. Is that correct?
Yes, ma'am. So I was paid for 5 quarterly payments of the 12,500, but there would have been the final, which would have been the February, March, April, that are coinciding with my last month of employment.
All right. Okay, so you have an agreement with the defendant. You began work. You performed the work as required.
Yes, ma'am. Again, I think it's important that my role was not a sales role in terms of having a quota and those type things. I mean, everything's a sales role. But my role was really to barter those relationships and those connections and get those meetings set up for the company. Their sales team and their quoting teams would put everything else together and present that. But it was my position to get those meetings set up and in place and have those and go with the team to make those introductions.
Okay. And then how did the contract come to its conclusion? How did it come to be that your final workday was going to be in August of this year, or in April rather of this year?
Yes, ma'am. So Lynn held Monday sales meetings, and I was always there just so I could kind of have my finger on the pulse on what was going on with the company, where they might be moving and going. And I started picking up some subtle nuances that one of the directors above Lynn was really wanting to take the company to the next level in terms of income revenue. And so I detected some subtle nuances about how everybody was being held a little bit more to a quota or a number. And when something was slipping or late, they were wanting a little bit more details. And this was from the sales team, not me, because I wasn't really sales associate listed. And so I reached that conversation with Lynn, and we both had a discussion, and we met in January, I think, and it's probably in my documentation with you as well. We met and discussed it, and he basically confirmed that that was the direction. And I understood that, the top directors wanted to get to $1 billion a year, and that's going to mean driving sales. But that was never my role because that wouldn't work in my situation with my connections at the state. So I asked him to go back and clarify with his boss that if that was the direction, maybe I should start looking somewhere else. So I got a response back from him in February and started looking elsewhere based on the conversation we had with him, that he agreed that it was probably his boss's direction, that, he wanted to move a different direction. And so I probably had 30 to 90 days to try to find something else. And that's when I started looking. And then I gave my notice around the 1st of April, which was within that 90 days. Actually, it was less than the 90 days, but it met the 7-day notification parameter of my agreement.
Okay. So around the 1st of April, you told them, I'm quitting. Here's my 7 days notice.
Yes, ma'am. And told them that my final day would be April 30th. And I think I actually sent that on March 27th at 11:45, where I sent that to Lynn, advising him.
All right. And in your month of April, did the defendant indicate that you had not done anything, or that there was any concerns about your performance or about being paid? Anything
No,
at all?
ma'am.
Okay.
No, ma'am.
And final day comes and goes. Did you return everything that you needed to give back to the defendant?
Yes, ma'am, I did that. He and I had spoke about returning my laptop, which I think I did on about the 17th of the month, and sent pictures, and that was all done and confirmed, and all that took place. And so everything that I could do to wrap up any pieces was done in advance.
All right. And then after time passed and you did not receive payment for the month of April or for any portion of the MOU, did you reach out to the defendant about getting paid?
Yes, ma'am, I did. And I wasn't able to get a meeting or a response with Lynn. And at the guidance of some external legal guidance that I had, obviously their request was to try to solve this at the lowest level, which was what I tried to do. And when that was unsuccessful the first time, Lynn was going to go back with his boss and see if they could get this paid. And then finally he came back, said that his boss was not going to pay it. And so then I reached out one more time to Lynn, or several times. I think there's a documented set of dates and times that I tried to call to set up a meeting just to see, could we resolve this? And we could not reach an agreement. And so based on the guidance that I received, the next step was to try to go to this level of the civil suit to see if we could solve it here, which I do think everybody wants to do. I just don't know how we get there.
Did the defendant indicate in their answer to you that why they didn't want to pay you?
Lynn's response from his boss was that his boss felt that he had been very fair and given me plenty of time and adequate, chances to move forward, and that he just didn't feel like he should pay the final MOU or the final month's salary. And there was a confusion about the date. I'll throw this out, but I don't have proof of this because I wasn't privy to the email. But I think that an email was sent to Lynn's boss that miscommunicated my last date. It did not come from me, but I was always very clear, and I have information in the packet that you have for me that my date was always April 30th. It never wavered or changed from day one. But I think that date was miscommunicated to Lynn's boss, and that may have caused him to feel the way that he did. He felt like the date changed on him, but it really didn't. Not for me, not ever.
All right. And did you submit a copy of your notice to the defendant that you were going to be ending your employment with them?
Yes, I did.
I'm kind of looking through here at what we got.
Yes, you should have a copy of an email sent on March 27th from me to Lynn, and it just basically states my last day and the things that I had done and gotten finished for him, and what my outstanding payments were.
All right. I'm going to share my screen. Mr. Brody, I'm making sure that there's nothing here. Okay, do you see my screen, sir?
Yes, ma'am.
All right, is this the email that you're referring to that is your notice of termination?
Yes, ma'am.
Okay, and so this is dated at the top here, March 27th at 11:45. Quick update and request. It's actually a response to a previous email and then it's marked high importance.
Yes, ma'am.
Lynn, I wanted to reach out and provide you with an update to my status and ensure we have an exit strategy we both agree upon. When we last met at the end of January, you met with Khalid. NetSync expressed we could get my back payments caught up, and and you were good enough to allow me some time to find new employment. Thanks for the salary payments. I've not secured a position yet, but feel I'm getting close. I'd like to request my last day be April 30th. Payment now for past due quarterly payments. So there was already a dispute ongoing at the time you were quitting about
Yes,
payment
ma'am.
outstanding?
Yes, there was
Okay.
about $25,000, I think, in MOUs for the previous two that were being held up, and some monthly payments. But I think at the end, or maybe it's the 5th, I'd have to look at the date in the package you have, but I think on the 5th of April, they got everything caught up except the final, what we're disputing here, the final month and the final MOU.
Let's go through this then, because this letter is pretty detailed here. So it says
Yes,
first
ma'am.
you were looking for payment from November of 2023. Did you get paid that?
On around April 5th, yes.
The answer is yes, you got paid for that one. So number one, not part of your claim today. Number two, payment for past due quarterly payments for $12,500 for November, December, and January. Did you get paid for those?
Yes, ma'am.
Okay. March salary request that was submitted in April. Did you get paid for the time you worked in March?
Yes, ma'am.
Okay. Number four, you wanted your last salary request. You were going to submit it on May 1st for the month of April. This is the one you're suing over?
Yes, ma'am.
Did you submit your final request on May 1st?
Yes, ma'am.
And then final quarterly payment due that day for February, March, and April. I'll be submitting that one. Did you submit your final quarterly payment?
Yes, ma'am.
Okay. And then you asked about dropping your laptop off. Did you receive a response to this email on the 27th?
Lynn is really good about responding. I'm going to say yes. My guess is that he told me he would check with Khalid and get back with me.
Mr. Grody, don't make any guesses. My real question is, do you have a copy of a response? If you don't, that's fine. But if you do, I'd like to see it.
Okay. Do you want me to look for it right now?
If you don't have to, just do you right now as part of your information, have the response from Lynn to this email that you sent him?
I would say yes, because I'm pretty meticulous about keeping everything. So yes, I would think I would have it.
This is one dated, so this is March 27th. And then this is the next one in your documents. It's dated April 30th. And it then you said, I want payment now, pending. I dropped off my laptop, turn off my email, pending, turn off my door, pending. I have an outstanding amount of $45,833. And so, Mr. Grody, is it your testimony today that after you sent this email, April 30th, they paid you for the top two payments?
Yes, ma'am.
Okay. And did they pay you for the final payment, or rather for your work that was done? This is the one that wasn't get done.
Correct. The April payment was not paid. That's still outstanding.
All right, Mr. Grody, this is some more emails in that chain. And I see here's one from someone named Sherry Chin. And it's from her to you. I sent you yesterday for the 25,000 to clear up everything. I was informed that your agreement ended March 31st. So is this the first time you would realize that you were being told that people thought you had quit the month prior?
Yes, ma'am.
April 30th at 8 a.m. This is the next day. She goes, well, I sent you the money for the 25K. I was told you had already quit. You said, no, or let me know if that's not true. And you wrote her back 14 days later and said, no, my final date was April 30th. Please let me get a resolution to this.
Yes, ma'am.
All right. Ms. Sherman, so far, is there any objection to the two things that I've really looked at would be the contract from subcontractors, although that actually was defendant's exhibit. And then this
Yes,
one
ma'am.
here, this chain of emails, any dispute that this is an accurate email from the plaintiff to the defendant on or about March 27th about termination?
Yes, Your Honor, we don't have any objection to this.
All right. All right, so then Mr. Grody, after you had these emails, still haven't been paid.
That's correct, ma'am.
Have you received anything from the defendant that indicates a specific reason you're not being paid? Or is it still very much they thought they'd been fair and they didn't need to pay?
Yes, ma'am. It's the latter.
All right, Ms. Sherman, do you have any questions for Mr. Grody?
Yes, Your Honor, just a few. And
Absolutely.
I don't know if it would be helpful. I think for Mr. Grody, I can get through without showing any documents, but I may have to ask to share my screen if necessary.
Do that.
Well, actually, let's do that if
All
I
right.
may.
Standard caution.
Okay.
Remember, when you share your screen, it shares a lot of things. So always
have-
be cognizant. I know. As counsel, you get to do Zoom a lot now, but I've had some interesting moments.
Okay. So let's see here really quick. Well, I should have been ready. I don't know how to share my screen on here. I'll go forward as I figure this out. Mr. Grody, again, my name is Sarah Sherman. I represent NetSync Network Solutions. And we've never met, correct?
Mr. Grody,
Sorry, my mouse was on the wrong side. That's
Oh.
correct.
Okay, I've got this figured out. Okay. And the court's been very thorough, so I'm not going to tread on anything that Your Honor has already covered. Mr. Grody, do you recognize this document right here that was as part of the papers you filed with your original petition?
Yes, ma'am, I do.
Is this your handwriting?
Yes, ma'am, it is.
Okay, and these look like notes of agency meetings, correct?
That's correct.
And you said you kept detailed notes
Yes.
of everything? Okay, so we have at the top of the agency meetings, it looks like the very first one is listed as info blocks 8/10/22, correct?
Correct.
And then we go all the way through from August of 22 up until November 27th of 2023. Is that correct?
Correct.
With DFPS.
Correct.
Right. Can you tell me what meetings were held after November 27th, 2023?
So there were still meetings that went on but weren't logged here because the agency or the company, excuse me, not the agency, NetSync had their people pull back and stop engaging me at the same degree that they were. The two sales staff that I worked with directly that reported to Lynn were not, I don't know what the guidance was given there, but they weren't engaging me at the same level that they were before. But I was still in follow-up conversations and talking with things that were in motion, moving forward all the way up until the April timeframe with other vendors, companies, and agencies about NetSync and what I did for them.
Can you identify any of those vendors or agencies that you were still communicating with?
Sure. There was one that I had lunch with about a month and a half ago that Matt Kelly works for, and it is a camera company. And they stated that they were having trouble reaching their sales contact at NetSync, and I gave them some guidance and told them what I felt they ought to do to move this along to get the company a shot at $4 million up in the Dallas area. So, and I'm sure Matt would verify that for you as well as another person that was there at the meeting with me who is on this list that we met with them as well.
And who at NetSync did you tell about this meeting?
No one at NetSync was communicating with me anymore at that time.
Okay. And here, I can stop sharing this. Mr. Grody, you said that you returned the laptop on April 17th, correct?
Correct.
Why did you return the laptop on April 17th if you were going to continue working through April 30th?
Because I had a backup working functional situation. I was able to use my desktop to do my normal work. The only reason the company really sent me was a laptop was for some official things and to get through the VPN systems through them. But those weren't needed for me to access my NetSync emails and anything else that I needed to do my work.
Okay, so you were still working, it's your position that you were still working after you returned your laptop?
Absolutely.
Okay. Let me see if I can get, I apologize. I'm not very good with Zoom. I don't know how to stop sharing my screen.
Sometimes it moves around, but it's a little at the bottom, have a little red box that says stop screen share.
Oh, it's on the other screen. I have too many screens.
No, it has
Okay,
this,
so you're on there.
it happened, Ms. Sherman, it moves around. So it's usually in one zone and then suddenly it's a different one.
And
Okay.
just for clarification, that company that I couldn't remember while we were talking about Matt Kelly, it's Verkada, Verkada.
Okay, Your Honor, I believe that's all I have for this witness.
Mr. Grody, is there anything further?
No, ma'am, not that, not unless there's any clarification that I can give here. I mean, I just would like to get this resolved for everybody. It's unfortunate. I've been around a long time and I've never had to be in this situation. And I know Lynn and I respect Lynn a lot, and I think he feels the same way. But we kind of got to where we are, and the decisions were above him. I think that we're kind of pushing the direction here.
Okay. Mr. Grody, so per the agreement y'all had, you were supposed to provide them with an invoice at the end of the month. And I asked you if per the email you sent them that you did supply that final invoice. And you said you did, correct?
Yes, ma'am. I have copies of every one I've sent ever.
Was that something you submitted to us?
Um,
The very last one, the one that you're suing over. The
no,
one that
ma'am. I probably didn't
submitted
send you the
May
detailed
1st.
invoice, just a recap of the amounts and the dates.
Do you actually have that invoice?
Yes, I do.
Can you submit that to us now so we can take a
I
look
sure
at it?
can. I sure can. Hang on one, or actually I'll stay on mute, but I should be able to paste it into the chat probably. Is that the best way, or do you want me to send it to the court address?
You got to email it to us. If you have it on your
Okay.
screen, we can allow you to share your screen and show it to us, but ultimately the easiest thing to do is just email it in to us.
Yeah, I can do that.
Okay. So that's the one, right? You want to get paid for the work you did in April, you got to submit an invoice. You said you've got that. You said that you did it and that they didn't pay you for it. And then
Yes.
you wanted to get paid for your portion of the MOU. And again, when I go back and look at the terms in the agreement about that, it says, because that's actually in the task order. I'm not clear on how you're supposed to be paid. So I'll share my screen again, Mr. Grody, and you tell me your understanding of what the contract says. So here we got this contractor task order, right? This is the stuff that you're supposed to be doing. Working in an environment to identify opportunities, support the sales effort, drive and set perimeters, take a proactive approach, build key relationships, learn and have a good understanding of products, thorough understanding, some travel, other duties. I mean, this is a hell of a job description, y'all. I want to get paid $100,000 to just be upbeat and be proactive. There's very little hard concrete required here, right? And so then it continues on. We'll pay you in monthly installments. Okay, we've covered that. He's supposed to give you an invoice. He says he's got one of those. But then this one, the second one here, contractor will be paid $50,000 MOU. And what is MOU? A memorandum of understanding?
Yes, ma'am.
Was there a memorandum of understanding?
It would have been, and again, I may have to defer this to Lynn or their legal counsel, but it would have been between NetSync, and the first year was a memo of understanding with one of their very large partners that submitted that $50,000 of funds to them, the 12,500 for the 4 quarters in year one. And at the end of year one, it's my understanding that that company did not re-up on the funding of that MOU for a second year. And they were going to look internally to find those funds to fund this for me, but that was not a problem at that time. And Lynn, correct me if I'm wrong on that.
He doesn't actually have to do that, sir.
Okay, sorry, ma'am.
It's okay. It's your case, sir. So you're supposed to show me everything. I'm not understanding. Like, okay, this is so. How do I know if you don't do any work? It just says you're going to get paid that. And I mean, I don't know what the MOU says, and I don't see a copy of one.
Right. I never received it, but you know, I can tell you that fundamentally the concept behind it was that we would continue to partner to help grow the business. And obviously the company, and I'm not mentioning their name because I don't know if there's any kind of proprietary guidance, and maybe NetSync's legal counsel can comment on that if you allow them to or want them to, but they obviously wanted us to continue to move their products or suggest their product solutions as we were going out trying to get new business with these state agencies. And so that's why they put these funds into there. It was kind of a way to help us help them grow their market share in a nutshell.
Okay. Anything else, Mr. Grody?
No, I found one of these files and I'm looking for the second one right now to attach for you.
Okay. I would like to see that, the invoice. But all right. Well, Ms. Sherman, I'm interested to hear from the defense. I mean, per the paperwork, looks like he's owed the money.
Yes, Your Honor. Defense calls Len Noble as corporate representative of NetSync. And Your Honor, I'm going to go through this as quickly as possible. I'm not going to try to go over anything that you've already done, but we'll just try to get everything in and recapped from our side.
Okay, it's your case. Don't feel I'm paid to. I'm not paid an hourly rate.
Okay,
Mr.
Noble. Oh, sorry, Your Honor.
Mr. Noble, just remember that you're under oath. Go ahead.
Yes, ma'am.
Mr. Noble, can you please state your name for the record?
Lynn Noble,
And where do you currently work?
NetSync Network Solutions.
Can you tell us a little bit about NetSync as a company?
Generally speaking, we're a technology solutions provider. We do things like network infrastructure, both wired and wireless, voice and video solutions, security, both network and cyber, data center, managed services, those types of things. Anything to do with technology to support a customer, that's kind of what we do.
And what is your title?
Senior VP of Sales.
Very briefly, can you tell us what your role is as Senior VP of Sales?
Yeah, it's to drive strategy within inside our sales organization, to build sales teams and go-to-market solutions that help support our customers. And we do that through the technologies that I mentioned before. So work with the sales teams, work with our internal support teams to provide value for our customers.
Okay. And ultimately, Mr. Grody was part of that sales team,
Yes, ma'am.
correct?
Yes, ma'am.
Okay. And you were familiar with Mr. Grody, correct?
Yes, ma'am. Yes, ma'am.
How did you know him?
We met, I mean, both of us have been in the industry a long time, have known of each other and met through mutual friends. So,
How did he come to work for NetSync?
um, how did he come to work? We had met several times to talk about what we were wanting to try to achieve at the state of Texas, and based on that, we brought him on as a subcontractor to support our team's sales efforts.
What were you trying to achieve with the state of Texas?
From my perspective, our biggest objective was to grow the business inside the state of Texas. We have some business or had some existing business inside the state, but we were trying to grow the business from a revenue and a profit perspective within the state of Texas accounts and agencies.
So do you mean state agencies as opposed to private businesses operating within Texas?
Yes, state agencies. Yes, ma'am.
Okay. And I'm going to share my screen. Okay. Mr. Noble, can you see the screen?
Yeah, it's small, but yes, ma'am.
Okay. And you are familiar with this document, correct? It's the subcontract agreement that,
Yeah. Yes,
that the
ma'am.
court has shown us already? Okay. And as the court briefly noted, under section 2.1, independent contractor, was Mr. Grody an independent contractor, not an employee?
Correct.
Okay. And then the court also had pointed out that under section 7.1, the term of the agreement commenced on the effective date and continued until either party initiated termination. Is that correct?
Correct.
Do you have any understanding of whether there had to be a reason to terminate or if the parties could just terminate as they wished?
As they wished was my understanding.
Okay. And under section 8.7, no waiver. Do you have any understanding about what this section says?
Again, it was my understanding that was more about that we had to have no reason whatsoever, either him nor us, for termination.
Okay. And then we'll skip down to the task order. And the very first section says contractor responsibilities. Can you generally tell the court what Mr. Grody's responsibilities were under the contract agreement?
Yeah, from my perspective and my team's perspective, it was him working in a sales engagement, and really it was a business development role. And that if you read in that agreement, it talks a lot about not only engaging meetings but also driving business and net new opportunities. So, for me, how I looked at either success or failure was our ability to drive additional revenue and profit for the company.
Okay. And so based upon these contractor responsibilities, we jump down to the terms of payment. And we've discussed this quite a bit, where we have the base of 100,000, which was the $8,333 a month. Now, I think that's pretty simple, but let's dig in. And I think the court is interested in hearing a little bit more about this MOU. Can you explain what on earth an MOU is?
Yeah, the acronym itself is Memorandum of Understanding. For us in the sales world, it's basically performance driven, right? The payments are made, as you see there, based on, and were authorized by myself and the account team. And it was based on the performance or the return. And as I stated earlier, that return was based on our ability to drive additional revenue and profit inside the state of Texas and the agencies. So it was subjective based on what we believe to be the results we were looking for in reference to additional business and opportunities at the state of Texas.
Okay, so you just said it was subjective, it was a subjective analysis that you performed, correct?
Myself and the account and the other salespeople, yes.
Okay, and then we also see something not mentioned earlier, that in addition to the base salary and the MOU, the contractor will earn 2% of gross profit associated. So that's a commission-based component, correct?
Yes, ma'am.
Okay. And it's your understanding that's not an issue here, correct?
Correct. As far as I understand, correct.
Okay. Just to go very fast, showing you what's been marked as NetSync Exhibit 2. Are you familiar with this document?
Yes, ma'am.
Okay. Is this just an accounting of all invoices and payments made under the contractual agreement?
Yes, ma'am.
Okay. Exhibit 3, are you familiar with this document?
Yes, ma'am.
Is this an accurate reflection of all of the payments that were
Yes, ma'am.
made?
Yeah.
Okay.
Our understanding, we paid him $244,000. Yeah.
In total?
Yeah.
Okay, jumping on. Okay. Mr. Noble, this is been marked NetSync Exhibit 4. Are you familiar with this document?
Yes, ma'am, I am.
Okay. Can you tell the court who Hannah Paul is?
Yeah, Hannah Paul is the account manager on the state of Texas that we're partnered with Mr. Grody, or Butch is how I know him.
And who is Jason Osuna?
Also, the other account manager that supports the state of Texas, and that was working with Butch as well.
Okay. So they worked with Mr. Grody. Were they his superior or were they equals?
In my mind, they were equals.
Okay. They had personal knowledge of what Mr. Grody may have been doing, as well as whether he was performing under the contract?
They did, and we met periodically to discuss that and make sure everybody was on the same page. So yes, they had that knowledge.
Okay. And we can put this up. I'll try to get it kind of where both of it is. But what did Hannah tell you about Mr. Grody's performance under the contract and the services that he had provided to NetSync?
I think generally speaking, if you look at that, she did acknowledge that he did help with the engagement of meetings, but that's only one small portion of what the responsibility associated with the job is. And she mentions a few accounts, Health and Human Services, Comptroller, DFPS. But as far as business resulting from those meetings, she said it was very minimal. And I think she lists a few of those. And even one, I think if you look down below, one was Texas Facilities Commission, which revenue-wise was about $50K and had a small profit. And then Texas Water Department's very, very similar. And then the Texas Department of Housing and Community Affairs was another engagement. But we were already doing business there. But overall, it was very little return on the investment from Hannah's perspective.
Okay, what did Jason tell you about Mr. Grody's performance?
Jason said there was no impact to the business. Jason, just to be clear, Jason and Hannah support the state of Texas, and then Hannah has a few agencies on her own. And Jason's comments in reference to the agencies that he was working, there was no value in reference to what Butch had brought in reference to engagement with the state accounts, and no return from a revenue or profit perspective.
Okay, so was it NetSync's opinion that Mr. Grody was not performing the services as required under the task order on the contract?
That is correct.
Okay, and just for formality purposes, there was a native file, a spreadsheet that we marked as NetSync Exhibit 4A. Do you recognize this file?
I do.
Is this the file from which the previous exhibits were pulled?
Yes, ma'am.
Okay. And who sent this to you, Mr. Noble?
This probably came from Sherry, our accounting department. So
Okay. And we saw an email with her earlier. Okay. I will stop sharing my screen. Okay. So can you explain to the court what happened that led to the ending of the contractual relationship between NetSync and Mr. Grody?
I think at the end of the day, it goes back to the performance and our understanding, and this was the understanding of all parties, and Butch and I had this conversation quite often from the very beginning, that we'd be measuring the success based on performance, and that performance would be based on business opportunities that turned into revenue and profit for the company. And we agreed that we weren't where we needed to be, and we talked about that regularly, and actually had some strategies and meetings with Jason and Hannah and those types of sessions to see what we could do to improve. But it never came to fruition. We feel like in these scenarios, you know, you have to invest into either your employees or your subcontractors and give them time to build that business. But after 16, you know, after a year plus, we start evaluating it pretty heavily to see what type of return on our investment we were getting. And once we started looking at the numbers, obviously that there was not much of a return. We're spending the amount of money we did. And then if you look at the profit or the revenue generated from those activities, it was very, very little. So that's when we decided and agreed to go our separate ways. And like Butch is a friend of mine. I think both of us hate being in this situation. At the end of the day, we wanted to continue both the business and personal relationship. And that, I thought we were doing the right thing by extending or keeping him on and giving him time to go find something new. So for me, I guess it was hard for me to understand that, hey, we were trying to do right in this situation and give you additional days. But he mentioned it early, 30 to 90 days to continue to find a position. And then we ended up in this situation. So it was just doing the best to work through it.
Okay. Would you agree that, so at least by January of 2024, everyone understood that the relationship was no longer supportable?
Yeah, we had been talking about it, as he stated earlier, just kind of talking about the lack of success and where we were at. And we were all very clear in reference to how we measured that.
Okay. And you kind of hinted at it, but just to be clear, at the point that NetSync realized that the relationship was not beneficial,
yeah,
why did NetSync keep paying Mr. Grody instead of just terminating the contract with a 7 days notice?
Mainly because we just wanted to make sure we ended things on good terms. And at the end of the day, like I said, there are personal and business relationships here that we wanted to continue in the future and didn't want to harm those, and wanted to do the right thing and support him until he found something else to do.
Okay. And are you aware of anything that Mr. Grody did for NetSync during those last few months, maybe say January to April?
I was not really aware of what his day-to-day activities were.
How would NetSync know whether Mr. Grody had been doing any work at all for NetSync?
At the end of the day, we wouldn't unless it was documented. And like I said, the metrics by which we measure things are based on the opportunities that come to fruition in reference to sales and what we see from a revenue and profit perspective.
So did NetSync see any opportunities or sales from Mr. Grody from January to April?
No, ma'am.
Okay. Okay. And you understand obviously that in June of this year, Mr. Grody sued NetSync, correct? Which is why we're all here today.
I do. Yes, ma'am.
And what is your understanding of what Mr. Grody is seeking from NetSync?
Probably that, I think the 20,000 that he mentioned, yes.
Okay. And what is NetSync's position as regards to that?
I think at the end of the day, we'd just like to be able to resolve this on good terms and move forward.
Does NetSync believe they've already paid Mr. Grody everything that he has, that NetSync is obligated to pay, and to provide him with compensation for all the services that he did actually perform?
I think that we believe that the services that we needed to be performed were not, and that we paid him more than ample for what he did do, and that we do not owe him any additional money.
Okay. And Your Honor, just for the record, you're also aware that the NetSync filed its own counterclaim, correct? The NetSync filed a counterclaim against Mr. Grody in this action? Is he frozen?
Mr. Noble?
Were you asking me or I'm sorry?
Oh, yeah, sorry. I was asking
I thought you said
Mr.
Your Honor.
Noble.
I
Oh, well,
apologize.
I did. I told the judge something super fast. But Mr. Noble, you are aware that NetSync filed a counterclaim in this action against Mr. Grody, correct?
I am.
What
yeah.
is your understanding of the basis of that counterclaim?
That it's lack of performance, based on lack of performance. So
Okay, and NetSync did retain counsel for this action, correct?
correct.
Okay, Your Honor, I have nothing further from Mr. Noble.
Mr. Grody, do you have any questions for Mr. Noble?
No, but I do have just a couple of points of clarification.
Not yet, Mr. Grody.
Okay,
Just-
got you.
We're
Thank
going
you.
back and forth. Like you said, you were all done, so we moved on to the defense, right? So now,
Gotcha.
if you have no questions for Mr. Noble, Ms. Sherman can call her next witness. So, Ms. Sherman, go ahead. It may be that you answer the questions I have in your next witness.
Oh, Your Honor, the only other witness was going to be me on attorney's fees. So as I understand it, that won't happen. We've also filed an affidavit that's in the court's record along with the fees. So no, there are no other fact witnesses for NetSync.
Okay. Mr. Grody, did you ever find the invoices that you said you submitted for your last month of work?
Yes, ma'am. I submitted those, Judge, and sent 2 chat messages to you and your assistant that they should be in your inbox.
Fantastic. Let's see if those have come through. Because I have a couple of questions that weren't answered that are necessary, right? So let's just take a look here. Brigette, do you see anything that's come through? Oh. Sorry, my computer just froze on me.
Your Honor, I do have it, and I'm more than happy to share my screen with you.
The invoice for the work you did in April?
Yes, Your Honor. There was an email that came through with an April invoice and an invoice
Okay, yeah, it was
February
also
through
sent to
April.
Ms. Sherman.
All right, well, if you want to show it, that'd be helpful because I mean if we have to go through a firewall and then we have to get loaded into our software. So if you have it, I'm interested to see that.
Of
The
course.
the invoice in May
Sure.
for work performed in April.
Okay, so here we go. Okay, so for the avoidance of doubt, here's the email from Mr. Grody. And so here is the email regarding April 2024 monthly payroll invoice. And let's see.
Review and
Tuesday.
approve my monthly salary expense.
And then just let me know when you're ready for me to open up the document.
Maybe I'll open it up now, thanks.
Popping up over. There we go.
All right, well, that is quite vague, right? So now I'm curious then. That leads me to some questions. Okay. So, and this is for either party, for Mr. Grody or for Ms. Sherman on behalf of NetSync. Do we have copies of the invoices that the plaintiff submitted for the months prior? Do they differ in any great way from this? Are they more detailed? Or are they all, hey, pay me?
No, man, they're all exactly like this. This was the agreed upon format. The only thing that would have been different, but they're not brought into this case today, would have been an invoice for reimbursement for fees. And what that means
Okay.
is if I took a client out for lunch to
Yeah,
meet
no,
with them.
I got it.
Yeah.
Reimbursement of fees is different. That's a different section of the contract too. But I just, is there, Ms. Sherman, from your clients, is there any dispute that this format and the description provided for work performed in the last 30 days is identical in nature to all the invoices he'd been paid on for the year prior?
Let's see if Mr. Noble knows. Mr. Noble, are you aware? You said that you approved.
Yes, and they were all the same. I could go back and look at each individual one to verify, but it's my understanding that we pretty much have the same format. So.
Thank you.
Okay. And then is there an actual written memorandum of understanding about that? Because the agreement, the terms contract says that we'll be paid 50,000. I'm going to be very specific about the language because it was right in the subcontract agreement on the contractor task order at the bottom of page 5. That second larger bullet point under terms of payment says contractor will be paid $50,000 based on the below accounts, which will be authorized by account team and management and paid on a quarterly basis. I'll share my screen. Y'all can see why I'm asking some questions. Here's what's kind of where I'm drawing a loss. So as I look at this, right, and I'll zoom in and make it even easier. It says on the contracts below, right, on the below accounts, but there's nothing actually below that dot. It goes to a whole nother one, and then there's a list below that, but that list strikes me as being the one about this 2% profit. So I don't know what he's getting paid on. And testimony I heard from Mr. Boyle, or Mr. Noble rather, was that it was a subjective analysis that was not based on commissions. That was something different. So I guess what it comes down to is this. He worked there for a year, right? Here's where I'm at. He worked there for a year, and every 30 days he provided you with an invoice that is as vague as the invoice I just saw. And without fail, he got paid regularly, like per the show, Ms. Sherman, what you showed. I can see that he got paid every month without any issues. So no one ever said to him, that's not enough detail. We don't think you're doing it. We have suspicions, nothing. He got paid, no problem. So I don't see any reason to think that he wouldn't get paid for his last month when he sent you the exact same thing before. So if there was any concern about his performance, the only evidence of that is an email dated August, 4 months after he already raises the dispute that he wants to be paid. But I don't see anything that shows in historical fashion that there was a concern about performance before he quit. What I heard, what I think both people agreed, or what is a reasonable conclusion, is that defendant wasn't getting benefit of what they weren't getting bang for their buck, right? We were paying a lot of money. We were hoping we were going to get more contracts. We were hoping we were going to get increased sales at the state and the municipals and the county levels for winning these organizations. And we're not seeing that buy-in that we wanted. But right, nothing about he'd been doing it has been wrong. And as the contract is clear, either party could have terminated it. The defendant did not terminate it. And it may be, I appreciate wanting to keep up a personal relationship, or do the right thing, but he should be paid per what I've got here for his last month of work. I don't see any intentional, I haven't had any evidence of fraud presented. What he did tracks with what he'd been doing, and there had been no issue raised about that. Mm-hmm. So for the 8333, I'm with him on that. What I'm less clear about is the payment of the quarterly MOU. Right, I know that he was paid for it before, but it's not quite the same thing because there is some approval method of it. What my question is here for Mr. Noble is, was there anything put down in advance about when it would be approved or when it wasn't? Because if his performance had been lackluster all that time, he'd been paid the quarterly payment before with no issue. Now it's being withheld. What's the reason for the changeover? And is there any evidence to support that other than that August email that says we didn't see the benefit we wanted?
Yeah,
that's where I'm coming, is on that quarterly payment. How do I know when I'd be paid or not? I mean, what if I did a great job? And you still thought, not good enough. Was that within the terms of the MOU?
Yeah, the MOU was based on myself and the evaluation of the account team as far as progress made in the accounts. That is correct.
Is that recorded anywhere?
Well, I think that contractor will be paid the $50,000 MOU based on the below accounts, which will be authorized by account team and management. And paid
what I'm saying is which will be authorized. Ms. Sherman, that seems very required. There doesn't seem to be which may be authorized. It doesn't seem permissive. It seems mandatory. So why would he not be paid his 1/4 share of the $50,000? Unless there is something in writing that you can look to says, no, this wasn't done. But it says will be paid, will be authorized. Not,
But
not can be authorized, not may be authorized, subject to approval. It just says it will be paid.
Your Honor, I think it's because it's contingent based on the below accounts, and
What are the below, Ms. Sherman, what are the below accounts? Remember, my original point is I don't know what I'm looking at below, because the accounts below it are about getting a 2% profit. That's about the commission. So what are the below accounts?
Your Honor, I think they're one and the same.
They are.
And what are those below accounts going to, how will those determine whether or not he gets paid this $50,000?
It's based on performance and driving additional revenue, which we've shown there is no additional revenue or profit in those accounts.
But he got paid on all the ones before it.
He did. And we were giving him time to work and grow the business. That's what I was stating earlier. At the end of the day, I know it doesn't happen overnight. We're trying to give him the opportunity to go in and grow the business. And once it came to sorry, go ahead.
Oh, Mr. Noble, I get that. Was that recorded anywhere? Because it's easy to say that now after you've not paid. But if you're just saying is that we were paying him under that framework, I would like to see that in writing or something that indicates these conversations took place with the sales team before August, after this was already begun.
I could get statements from the sales team that, yeah, we had these conversations throughout the agreement as far as
in writing.
I'd have to go back and look through emails. So.
Ms. Sherman, are you aware what I'm looking for here?
Well, Your Honor, and I think that's where it's important where the no waiver clause comes in, because as a legal matter, NetSync was entitled to pay him the $50,000 in the MOU, even if they didn't believe that he had earned it, and not be precluded from later saying, no, you have not earned it this go around.
Let's reverse it. If as today, he's saying that he earned it just because he was there. So what I'm asking is, if you're saying that he didn't earn it, I still need, like, the contract as written strikes me as vague and not easy for me to understand how I know when he's earned his quarter of the $50,000. Will be authorized, paid based on the accounts below, will be authorized and paid. And then below that, it talks about 2% of gross profit. So there's something lacking for me in the contract. And who wrote the contract, Ms. Sherman?
I don't know. I would imagine someone within the legal team at NetSync. I did not draft the contract, Your Honor.
But from the defendant side, the defendant created this document.
Correct.
Contractor will be paid $50,000 based on the below accounts, which will be authorized by account team and management and paid on a quarterly basis. In order for me to put there some clause in there, I'd like to see it.
I mean, Your Honor, when I read this contract and I saw the below accounts, and knowing that the point of the party's intentions with the contract was because of his relationship with the state of Texas, and we have a specific list of all Texas state agencies.
What was he supposed to do with that list, Ms. Sherman? So when I read it, right, contractor will get paid $50,000 based on the below accounts. Great. What was he supposed to do on these accounts, and how are they related to the $50,000?
And then that goes back up to the contractor's responsibilities. He was supposed to provide outside sales services.
And look at the responsibilities. There's no real teeth to any of these. It's a lot of niceness. Work in outside sales environment to identify opportunities.
But there's no evidence that he identified any opportunities during the time frame for which he is
and
in the MOU.
Sure, but Mr. Noble never required that, right? He kept getting paid based on that incredibly vague invoice, which is why when y'all I went, that's it? What'd the others say? And it turns out that they all will look like that. So I get entirely the defendant's position that we paid a lot of money and we didn't get anything out of it, or not as much as we were expecting or hoping, right? With complete deference to both parties. So I think everyone's acting fine. I'm just saying that in order for me to, he's got the 83, right? On the 15 grand, I'm leaning more his way just because I don't see why it would have been denied if it otherwise had been paid. Is there something that changed dramatically from the payments he got paid before, or they just suddenly looked at his work performance and realized, crap, we've been paying him all year and he hadn't done anything.
Well, no, and I'll let Mr. Noble correct me if I'm wrong, but I think what it was is that they knew at the time of the 50,000 payment for the MOU that he had not earned it. He had not actually sufficiently brought in any of the business. Yet, as Mr. Noble testified, they were still wanting to invest in the relationship. They were still wanting the relationship to work out. So they paid it. As a legal matter, they were entitled to pay it without waiving the future right to say we shouldn't have paid it. That's the no waiver provision. And so by the time you get to January, by December of 2023 and January of 2024, as I think they both testified, everybody agrees this isn't working. It's not working. I think that they were told, and I'll let Mr. Noble, I'm not trying to testify from that. I'm not a fact witness here, that no business was coming in. Nothing was moving. There was no traction anywhere. And so at that point, you have an understanding between the parties that there's nothing supporting another MOU payment. And I'll let Mr. Noble.
Yeah, I'll address your question, Your Honor. For me, to answer the question in reference to why did we pay the MOUs earlier, in our business, regardless if you previously worked inside the organization or not, these are long sales cycles that take months and sometimes years. And it takes time to build those relationships and get your teams engaged. And you have to be willing to invest in the effort, right? And that's what we were doing. We were willing to invest in the effort for a longer term return. And as Sarah said, after a while, you realize, and she mentioned it, we both agreed that that return was not there. And that's when we made the decision that we needed to go our separate ways. So that's why we paid the earlier MOUs, is because we were hopeful and I guess hoping that we could grow the business with Butch's help. But once that didn't happen, that's when we decided to go our separate ways. But we paid those as an investment, to be frank with you, hoping that we could help grow the relationships, grow the business, and see the return from a revenue and profit perspective. And if you look at that list of accounts that are on the document and go look at what revenue we have, very little revenue or profit associated with any of those accounts to show any return on our investment at all. And that's why we agreed that it was not going anywhere.
If he had put in the work and y'all just been unsuccessful in securing the bid, he still would you have still paid him?
It was performance-based. We were very clear. This is a sales position. There has to be a return. So
is it a sales position?
It is.
Mr. Grody, I thought in his testimony said this isn't a sales position.
He did, and that's a statement that I didn't. But if you look at the contractor's responsibilities, work in an outside sales environment, and it talks about taking the sale through the entire sales cycle. So yes, it was not just, hey, here's some relationships, go get after it. No, you have to be a part of the sales team. He was a part of the sales team with Hannah and Jason to go drive opportunities.
Like y'all had different ideas about what was going to be getting done. And so then after the conversations in January, where Mr. Grody indicated that he realized the company was going in a new direction, they were going to move toward quota-based sales project. Then the parties continued in the independent contractor agreement for February, and then in March, Mr. Grody said, I'll be out of here by the end of April.
Which we did not, just to respond, we did not change any of our stances or positions in reference to the sales position. It was always a sales position from day one. And we did not say we were going in a different direction whatsoever. Nothing to change.
That was his phrasing of it, Mr. Noble. That was his description of why the agreement, the partnership between the parties was coming to an end, is that he began to sense that it was going in a new direction. All right. Was there anything required to be provided by the plaintiff to the defendant in order to receive that quarterly bonus? Was there any documentation for that? Like for the monthly amount, there had to be an invoice that was submitted. How about for the quarterly bonus?
No, there was nothing submitted. Are you asking as far as like task and things he did?
Yeah.
No, it was all verbal in our engagement as a team.
Your Honor, may I ask Mr. Noble a follow-up question?
Certainly, Ms. Sherman.
Mr. Noble, when you would then sit down either with just by yourself or with your team to evaluate whether or not an MOU should be authorized, what documents and or information did you take into account to make that determination?
For me, it was feedback from the team to see if the relationships were leading to any opportunities. But I ultimately, like I've stated a few times, it's ultimately based on the revenue and profit that comes from any of these relationships. And again, I go back to, if you look at that list of accounts, we have none to show for it.
And when you say you look at any kind of revenue and to see whether any income had come in from those specific accounts or state of Texas accounts, you had accounting records and or just feedback from your team to evaluate? Is that correct?
I could go look in our systems to see what revenue associated with those accounts. That's fairly easy. But we all knew. We didn't have to look at the records. We all knew. We had that as an open dialogue. And Butch was actually in some of those conversations. We talked about what we needed to see as a result. That was never anything that was shied away from, and we talked about that from the beginning.
Okay, thank you.
All right, Mr. Grody, do you have any questions for Mr. Noble or any final statements that you'd like to make? I think I'm ready to come to the end.
Okay. Yeah, just a couple of clarifications, Your Honor. You had mentioned you made a reference to the 15,000. That quarterly MOU is actually 12,500. Just for clarification, just in case you wrote that down. The other thing that I thought was interesting was that you do have the negative feedback, which is the first, as you already read into that I ever saw in August, and that wasn't to me, that was internal. But I have a plethora more positive feedback from that same team and others as we went throughout the position, thanking me for getting a meeting set or an opportunity set. And so I think it's just important to kind of keep that in mind. There's two sides to every story, but probably the biggest thing that hits me about this is we talk about there were no opportunities, but really opportunities as the rest of this, as you've kind of seen, are kind of loosely defined because there's one, and it's listed as one of the agencies on this subcontract agreement with HHSC, where I got them the opportunity to bid on about a $350,000 to $400,000 project. Their bid didn't get accepted, but to me, that is an opportunity that I brought to the table for them, what they couldn't get before. And there were numerous others. The TFC was another one. And so there were opportunities. That was part of what I was doing. I wouldn't work if I wasn't producing something. But I think to Lynn's point, he is valid. You know, did all these things convert and equate to dollars for the company? Some yes, some no. But I think it's important to keep in mind it wasn't as one-sided as, you know, it might sound here in some of this. There were opportunities. They didn't all convert to sales or dollars to the company, but there was effort put in. I guess that's what I wanted to say. And then you made a very interesting, intuitive feedback earlier about how would I know that I wasn't doing good? There was never, I've been in state government 28 years and private sector about 16, and I have managed teams of 150 plus. I know one thing, that if my team is not performing, I have to communicate with them. I have to verbally and in writing, they have to know, because that's how they're going to be judged in their reviews and evaluated. And so if you don't tell them that, how would they know what you need them to change or fix or address? And so it's interesting that you made that comment. I thought that was very intuitive. But, you know, Lynn and I did talk. We're great friends. I hope we stay friends here after this, but it's unfortunate things didn't work out the way they did. But I just think those things were important. And out of those 7 companies or agencies that are listed on that agreement, we had meetings and opportunities with 5 of those 7. So it wasn't like the attorney stated that, you know, we didn't address those. We did. We hit some of them, some we didn't. But then there were many, many, many more that we had contact and conversations with that weren't on that list. And that was part of the initial agreement. It wasn't limited to that. The scope was all state. So I think those are kind of the last comments I had. Thank you.
Okay. Any final statement, Ms. Sherman? Otherwise, we'll give it parties a chance to summarize everything.
No, Your Honor.
All right. I really appreciate everyone's time today. Mr. Grody, Mr. Noble, Ms. Sherman, good job by everyone. we'll say it's very nice to have two businesses or two, business entities behaving very amicably with one another, right? You can have a disagreement, but everyone's been very respectful. In fact, Mr. Noble, Mr. Grody, you've both emphasized, a very collegial relationship. And I'll say that's refreshing. It warms my heart as a judge. I don't often see that. Or, understand people come to court because they've not been able to work it out. But anyway, I just want to say that, Ms. Sherman, you've handled yourself very nicely, as well as having documentation and then putting forth things. I appreciate that. Okay. Of the two claims that were bought, so on the original claim, on plaintiff's claim, it was a claim for unpaid wages per the contract as an independent contractor, and that's the base salary of $8,333 a month. And then a second claim for a quarterly bonus based on the same independent contractors agreement, and that one was not 15,000 as stated by me, who does my math badly, but 12,500. So I became a lawyer and then a judge, not an accountant, right? I was a marketing major, y'all. Okay, I do find that the plaintiff has met his burden of proof with regards to the basic amount of the contract, the $83.33. Nothing I saw about the invoices provided or the information provided or the agreement between the parties that he remain until the end of April indicates that he didn't otherwise fulfill the terms of the contract. And while there was a good question about the laptop being returned, he indicated that he was able to do, other things from his personal laptop, and I don't see any reason to not find that to be truthful, and everything else matches up. So judgment for the plaintiff for that $83.33. With regard to the bonus payment, though, this was real tight for me, but I do find that at best we're 50-50 and not more likely than not on behalf of the plaintiff. So the reason for that, Mr. Grody, is a couple of things. One is that it is a quarterly payment and not necessarily an obligation. It was based on some very subjective mantra, albeit it would have been more helpful if we knew what that was, but because you're an independent contractor and the parties entered into that contract independently and then lived with it for well over a year, I'm not going to interfere with it now, right? It strikes me as okay. Also, y'all agreed, it sounds like you understood in January that the good job was going to be coming to an end, that this contract was not going to be completed, or rather not continue on indefinitely. And there was no invoices provided about real work that took place after November. So for any of that early part of the period. And so for those reasons, I'm going to not find for the bonus payment. And then for the defendant's counterclaim, I've already explained that we wouldn't be able to entertain it because it's in excess of the jurisdiction. I'm not allowed to, you can't cram it down, which it's got to be kind of in a realm of reasonableness. Mr. Grody, you did a good job representing yourself. Ms. Sherman, you did a very nice job on behalf of the defendant. So there's no fees that go back and forth. So it's judgment for the plaintiff in the amount of $8,333 plus your cost of court. And then just some information for both parties. Mr. Grody, you absolutely can appeal my decision if you're unhappy with it, or if you think other evidence might be out there that may be helpful to you. For the plaintiff to appeal, and this is really for everyone's knowledge, Ms. Sherman especially, because it's a little different, Rules 500. If the plaintiff wants to appeal de novo from court, I think it's only $500. For the defendant to appeal, though, it's twice the judgment. So, and I don't have any discretion to change that, y'all. Essentially, if the defendant doesn't have it, that would be an affidavit of inability, and then the case would move on to county at law. Okay. And then one final thing for Ms. Sherman, Mr. Grody, Mr. Noble, everyone, is that on appeal, you're in a new court, and therefore you could seek a whole variety of new rules as though this trial didn't happen. It's called de novo appeal. All right. But if neither party takes any action within 21 days, this judgment does become final, and then parties are welcome to try to resolve it any way they shape. All right. Any questions, Mr. Grody? Any questions from you?
No, ma'am. Thank you, Judge.
Thank you very much. Ms. Sherman, any questions?
Yes, Your Honor. Are you going to be entering the form judgment on your own without the parties needing any
We
further?
appreciate y'all offer, but we've got to stock a form for this kind of a trial by bench, and we'll just fill that out and we'll take care of it today.
Okay, thank you, Your Honor.
All right. Anything else?
I don't believe so, Your Honor.
All right. Well, good luck to everyone. Thank y'all very much. And I am familiar with NetSync. I see you at certain conferences that I go to. So,
Yeah.
hey.
Yeah, have a good day.
All parties are excused. Thank y'all.
Okay, thank you, Your Honor.
And say enjoy the weather, but it's hot again. Never mind. False fall. It's already over. Gave us that little hope. All right. And then we had a case on recall, and I think we were able to get both parties available for that one. So let's move forward with that one. This one's going to be now 24-1364. Mrs. Drevno and Drevno versus Cynthia Nolan Wills. And I have Mr. and Mr. Drevno both here present with us. And now Miss Nolan, you're here with us as well.
And you'll just have to unmute in
You're
the
on
bottom
mute. You'll
left.
need to, in the lower left-hand corner.
Right there, I got it.
Fantastic. Good afternoon. Thank you both for joining us. All right.
Good afternoon.
All right. Mr. Drevno, neither of you are attorneys. Is that correct?
Correct.
No worries. You don't need to be one. And Miss Nolan Wills, you're not an attorney either. Is that correct?
That is correct.
Okay. Well, good job to all three of you for avoiding the disaster that is law school. I'm teasing. I'm glad I did it. And there's some poor law student out there right now who's like, she said, don't do it. Okay. All right. Well, then let me just give y'all a little bit of information and then we will get started and see if we can't resolve this matter for you this afternoon. Okay. So, Mr. Drevno, I'd say between the two of you, you both have an opportunity to speak, but when we're kind of beginning or we're going to go through things, it may be best if you sort of designate one of you to be kind of the lead speaker and the other person can be like, don't forget, right? Hey, ask that question. That way we don't have too many people kind of talking over. And then Miss Nolan, you'll be handling yourself. As the defendant, you absolutely can kind of just be, you're allowed to just sort of be quiet for most of it and see if the plaintiff is starting to establish their situation. You're not required to offer any information or to answer any questions out of turn. Plaintiff has to go first and then it's the defendant and then we go back and forth a bit. Okay?
I understand.
All right. Then who is going to be speaking on behalf of the plaintiff? Who wants to be kind of lead spokesperson?
I will be. Matthew.
Fantastic. Then Mr. Drevno, if you'll please tell me in just 2 or 3 sentences, why have you sued the defendant? If you're suing for money, how much money? If you're suing for property, specifically what property? Tell me that, will you?
So we are suing for a total of $3,500. We had an agreement with the defendant for a personal loan of $4,000, which she had made one payment of $800 towards that, bringing it down to $3,200. The other $300 is for a washer and dryer that we had sold with or to the defendant, part of a secondary agreement with her.
Okay, so you're suing on $3,200 from a $4,000 loan and $300 for a washer and dryer that you sold the defendant and she didn't pay.
Correct.
Okay. And is it a washer or a dryer or both?
Both.
Okay. All right. Ms. Nolan Wills, do you want to make a statement now or would you like to wait till the plaintiff's completed? It's totally your choice. It's not going to affect anything about how I hear the case.
I'm not sure what else is for them to complete, but I'd like to hear everything they have to say before I speak.
Okay, that's fine.
Okay, thank you.
All right then. If I go ahead, let me swear in all 3 parties though. So Mr. Drevno, and Ms. Nolan Wills, if you'll please raise your right hand for me. Do you understand that by appearing in court today and offering testimony, you are swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Do you so swear?
I do.
I do.
Okay, fantastic. All right then. On behalf of our plaintiffs, who wants to start and kind of give me the recitation of facts? Matthew, is that going to be you?
You want to do it?
Or you want to be Barry?
Yes. Yeah, I'll do it.
Okay.
So on April, 19th this year, Cindy had reached out to us regarding a personal loan. She originally started with just asking me personally, and I had mentioned to her that I needed to talk to my husband because it's not something that I would be comfortable doing just by myself. Okay. And so after consideration with my husband, we agreed to do it. We agreed to give her a personal loan in the form of cash. We give her $4,000 with a contract that was to be paid monthly of $800. In our evidence we sent to you, there's text messages showing that my initial message was that we were going to get paid $800 on the 20th of every month. However, per the email that we received, it was just stated by her that she would be paying $800 per month.
Let me, Mr. Drevno, I'm sorry to interrupt you, but this is a very important part of this when it's about a loan for money. So on April 19th, the defendant said, could you make me a loan? And you said, let me discuss it with my husband. and then the two of
Right.
you discussed it, and you agreed to lend her money.
Correct.
Okay. When did you actually give her the money? Do you know what date that was?
Yes, it was on April 18th. Well, it was April 19th, but per our Excel spreadsheet, it was dated on the 18th that we had also sent you. Is that correct, right? 18th? 19th. Oh, excuse me. I'm sorry, the 19th.
Okay. So
So
she
she
asked
asked
for
us on the
money,
19th.
you agreed to give her the money, and then you met up and you gave her cash?
No, so she works for us in Austin. We currently live in Tennessee. And so we have a business there, and she's a manager for us. So she's in charge of our money there. So she withdrew the $4,000 out of our reserve cash for the business instead of us sending it via Venmo or cash, or check.
So you authorized the defendant to withdraw money from your accounts for her personal use.
Correct.
Okay. And when did the defendant withdraw that $4,000?
On April 19th, 2024.
Did y'all put in writing via email or text message or old-fashioned handwritten letter anything about the amount of money being lent and the terms of repayment?
Yes. I originally sent her a text with the agreement, and I asked her to type up an email stating all of the details that I took. Cynthia, took $4,000, and I will repay you monthly of $800 to be paid in full
Okay.
by October of this year.
Yeah. So, Matthew, you texted the defendant and said, "We'll lend you the money. Here's the terms. Can you
Yes.
email me back and say the same thing?"
Yes.
Do you have a screenshot of the text message?
Yes, it should have all been sent to you. You should have all of this.
It may very well be in here, but we get so many documents that until I know I need to look it up.
Okay.
I've had.
Do you want me to send it again?
No. Let me open up the file. What I'm saying is that we have people who will send 85 exhibits.
Oh,
And
I
if I
gotcha.
looked at them all in advance, I'd never get to anything. I've had people send me hours of Ring doorbell footage for what I ended up needing to see 2 seconds. Right.
Okay.
So it may very well be that you did submit all these, but I haven't looked through everything. So let me take a look.
Okay.
Okay. So you sent her a text message and you said you've got a screenshot for that. And then
Yes.
the defendant, did she respond to that text message, or did she just send you an email that says, here's the agreement?
Both. She replied back saying, yes, I will do that. And then the very next day on the 20th, I reached out to her again and I asked her, hey, I needed the email from you, which she had then sent the email stating everything regarding the loan
Okay.
on the 20th of April.
Let me share my screen then, Mr. Drevno, and see if you recognize this. Okay. Do you recognize this? Is this a copy of
Yes.
screenshots of your phone? And there
Yes.
are 10 pages, and I think this can continue on the whole way. So let's take a look here. Okay.
And they are in chronological order.
Do they go get old? Like, is this the 19th and then it goes to the 20th? Does it go this way?
Correct. Yes.
Oh, great. All right, then let's start at the top here. So, Mr. Drevno, I see this as a screenshot. At the top, it says 12:55, and I can see here a date, April 19th, 5:17 p.m. Is the Cindy Nolan here? Is that the defendant?
Yes.
Okay, and who is writing on the on the left-hand side in all white? Who is this person?
That is the defendant. That is Cindy.
Okay, and how about on the right-hand side in the blue box? Who is that?
That is myself, Matthew.
Okay, and so between you and I, if I wanted to borrow $4,000, would you loan it? I'll pay back $500 a month. I've never asked for anything. I need to run it by Barrett. It's a joint account. When do you need it by? I've never asked for anything. ASAP. Let me talk. Give me a minute. My first thing to say is something that I would ever do. Your community is just not okay, especially for something like this. But after talking, we'll lend you the $4,000 on 2 conditions. You need to pay us back. Okay, so counter offer. She says $4,000, $500 a month, and you said no. We'll give you the $4,000, but we wanted it $800 a month on the 20th of each month until you get it paid off.
Correct.
You can take cash out of the safe and note it on the spreadsheet. This will be an interest-free loan, but you need payments on time each month. please type it up and send it to us tonight. And I'll send Barrett a message. Love, hate, or not, we're on a team. Don't wait, cry. Okay. This is just a repeat of the same thing. I need you to send the contract for the loan. This is that evening. Do you want it in an email? This is it. We're now hit the midnight. Just type it up. Give us everything, like the date, the amount, the payments, parties, print it out, sign it, take a picture, and send it to us. I will. And then nothing takes place after that. So the next message
It'd be a
is
text,
13th.
correct?
Okay. And so after she said I will in the morning on the 20th, did she send you an email that said those things?
Yes, that should be in the next slide of yours. Or one of the, it's the next one.
Okay. And is this the email that you received the following day from the defendant to yourself?
Yes,
Or
that was
to
sent
Barrett,
to
rather.
Barrett. Yes.
Okay, I, Cindy Nolan, received a personal loan on April 19th in the amount of $4,000. The agreement is for $800 to be paid monthly till completion. First payment due May 2024 to be paid in full by October 2024. So she calculated the number of months. So the only thing that this doesn't include is the due date of being the 20th of the month. It just says it's going to be paid every month.
Correct.
Okay. Ms. Nolan, do you recognize these text messages?
Yes, but I have to say, I didn't realize I left the 20th off the due date, but I do recognize the messages.
That's fine. Okay, so this is all accurate. And then this is an email that you sent them commemorating the loan?
That is correct.
Okay, fantastic. All right. And so then, Mr. Drevno, how much money have you received in payment in full on the loan?
So on May 30th, was it May 30th? Yes, on May 30th, we received an $800 payment via Venmo from Cindy for it. And again, I didn't message her until the end of the month because per the email, she didn't specify the 20th. So I gave her till the end of the month because I didn't want to cause any issues.
And you said that was on April 30th or May 30th?
May 30th was the first payment. Yes. Which you should also have a picture of as well.
Okay. So then after May 30th, you come now June 30th, June 20th. Did the defendant make payment on or about June 20th?
On June 20th, she did not make a payment. On June 30th, or where's the next message of the text? I don't know to give a picture of that. Oh, no, I did it. So we then switch over to a WhatsApp, another texting application, which you should have a picture. On June 30th, I sent a message to her saying, can you send this month's payment of $800 to Barrett's Venmo? Now, Barrett did try to request a payment from her at this time, but it seemed that she had us blocked or his account blocked from requesting payments. We received no payment or response. Then on July 1st, I replied with a question mark. And then at this point, she then replied with a text message saying, I have been advised after this notification to you, Matt Drevno and Barrett Robbins Drevno, that there is to be no further communication in regards in any matter currently in dispute. As communication is as follows, directly or indirectly in the form of a contract, of contact through phone calls, texts, chats, and or social media with myself, family members, friends, coworkers, and employees.
So that's this one.
Yes, that is correct. And then I replied, then you have breached our contract and we will sue you. And then there was no response. So, and then we filed this suit.
So I see here's May, conversations normal. June 30th, can you send this month's payment of $800 to Venmo? Nothing. July 1st, nothing. And then you got this message from the defendant. I've been advised to let you know that we're not going to communicate anymore.
Correct.
Okay. And then you said, well, you've breached our contract and we'll sue you. All right.
Correct.
In between this loan taking place, what happened with this washer and dryer?
So there should be a slide in there for the washer and dryer. I believe it's the next one. Yeah, in June. Now, prior to all this, I had gone out there to empty out a storage unit, and we had discussed the washer and dryer. And I said, "Do you still want the washer and dryer, or should I take it?" She's like, "No, I'll take it. I'll give you $300 for it." I was like, "Okay, cool." Which nothing came of it. There was no other communication afterwards up until June regarding it, where we reached out about the loan as well. So we had tacked it on to the loan as agreement from Cindy.
How did y'all come to a price for the washer and dryer? What was she supposed to pay?
It was just an agreement between us. It was verbal. I had said $400, or I believe I said $300 at first, and she's like, "Yeah, that's fine. I can do that."
Where were the washer and dryer?
They were in a home that Barrett and I were renting out, and when we moved out to Tennessee, she had stayed in the house, or she had basically replaced us with our name on the lease, and she took over the master bedroom there.
So y'all left the washer and dryer behind.
Correct.
How old were the washer and dryer at the time you left them?
They were brand new. I had them for maybe 6 months. And she was using them since we left in October of 2022.
Wait, had she moved out by this time in June the following year?
No, so she had still been living there, and she still currently does, to my knowledge. She took over the lease in, was it June or
April?
It would have been April or May of this year that we moved out officially, and then she signed a new lease with the landlord.
Okay, so y'all were renting a lease. Y'all moved. She took over
Correct.
your lease. You
Correct.
left your brand new washer and dryer in an apartment that you were renting.
In the house, yes.
Yeah.
Because we had already had our own. Yes.
When you left, because this is months after the fact, in October, when you moved out of the defendant moved in, did y'all have a discussion then about what's going to happen with that washer and dryer?
No. The discussion was that we were going to leave it here because we didn't need it, and we weren't going to move it with us. So we left it for her to use with the intent to come back at a later date to get all of our stuff out of there, because we had left other things in the garage as well.
Did you come back and get those things then?
We did. And
When was that?
when I came down, that was March. It would have been, sometime in March of this year of 24. I could pull up
So
my
in
record.
March, what was the conversation about the washer and dryer?
The conversation was, do you want it? Do you want me to leave it, or do you want me to take it? And she's like, "Well, you can leave it. I'll pay you for it." And I said, "Okay, well, how does $300 sound?" She said, "Sure, that's fine."
Is this the only thing you've got to show me this text message from June? Do you still want it?
Yeah, I believe so, in text, yes.
Did she ever respond in writing at all about this washer and dryer?
All that. The text message, when I said, "Do you still want the washer and dryer?" "Yes, I do, but I had and have a lot of money I'm paying out."
I'm reading it. That's the one I'm looking at that I'm showing, right?
Yes.
And is this the
Yes.
only thing y'all got about this washer and dryer sale to her? Do you still want it? Yes, but I don't have the money. That's fine. We'll add it to what you owe us. Okay, sounds good. That's it.
I believe so. I'd have to look back through other texts.
Okay. All right then. Miss Nolan, do you have any questions for Mr. Drevno about the testimony he just gave me?
As As for the washer and dryer, I do. A matter of fact, it was left in the home for 2.5 years, along with from October when they moved through June. His Barrett Drevno's brother lived in the house as well, so it was like a community washer and dryer. As for taking it, when he came down to pick up the rest of his stuff, which filled the whole garage, which I didn't charge like lease space for, he also did not have room to take the washer and dryer back with him.
No, Miss Nolan, do you have any questions? Because you can ask Mr. Drevno something. What you're giving me is testimony. I got
Oh,
all
I
that. That's fine.
apologize.
Do you have any
Okay,
questions for him?
so Matt, when you came back, you did not have room for the washer and dryer in your truck. Is that correct?
I would have made room.
That's not my question, because that's not what you told me. You really didn't want it because you already had a washer and dryer. So my question is, did you have room in your truck to take it back? Because I told you at that point you could have sold it. I helped you load that truck and you did not have room in that truck to take it back. You did say 400, but since I helped you load the truck, you reduced it to 300. Again, you left it for 2.5 years. I wasn't the only one to use it. Barrett's brother Peyton was also using it. So my question, she said to form a question is, you did not have room for it in the truck, and that is what you told me.
I did have room in the truck because I had gone to the house to fill up the stuff or fill the truck up with the stuff at the house. And then we went to a storage unit, which I then filled it up with more stuff. So there was plenty of space in the truck. When we had a conversation, I asked you if you wanted the washer and dryer, and you said yes. It had nothing to do with whether I had room for it or whether I needed it, which I obviously didn't need it, but I wanted to give you the opportunity to keep it. Otherwise, I was going to sell it elsewhere.
Which I also said, did I also not tell you if you could sell it, go ahead and sell it?
And then you offered to buy it.
The question was, did I tell you you could sell it if you wanted to sell it?
Correct.
Okay.
And I was under the impression that you were going to buy it. You had offered to buy it for $400, and then yes, I did reduce it down to $300 when you helped me load the truck at the storage unit, which you then agreed to. So yes, I did have the option to sell it.
Am I only supposed to be asking questions about the washer and dryer, or can I ask questions about the loan itself as well?
You can ask questions about the loan as well, Miss Nolan.
Okay, the loan.
Cross-examine the plaintiff about what he just told me.
Okay, the loan is correct. I did take the loan. They did give me the money. Thank you guys. I appreciated that. My issue with that is when they came down to sell the place I worked for them at, Barrett Drevno told me I only owed $2,000 in a form of appreciation for running their business. Barrett, did you not tell me that?
No,
Barrett, did you not tell me that?
no, I did not.
Okay.
Miss Nolan, unfortunately, even if he had told you that, it wouldn't negate the amount of the money, because you have to put it in writing when you make a loan. Or
I understand that, but he's saying that I owe for a washer and dryer that is not in writing.
But that's not the same thing.
Oh, okay.
All right, that's about property. There's something called the statute of frauds that kicks in when you have monetary loans, and that's exactly what this is, which is why it's a damn good thing for the plaintiff that they even got something in writing, or this whole thing would just be, well, don't give away friends' money, right?
Mm-hmm.
But y'all did put it in writing, and there is no dispute that the loan was taken out. So really, here's my question for y'all. Ms. Nolan, how much money do you say you've paid toward the loan of $4,000? Because they're saying $800. That's it? That's all that was paid?
Correct.
$800. Okay. And then the dispute is whether or not you owe money for the washer and dryer. Is there any dispute that do you have the washer and dryer still?
I do. It is still in the garage. Okay.
And how long have you had the washer and dryer since the plaintiff moved away?
I've had the washer and dryer since, I think I moved in by Christmas after the October that they left, I believe. So it's been in the home since October 2 years ago.
And do you use the washer and dryer, Miss Nolan?
Yes, ma'am, I do. Would that be considered a part of the sublet, since I was subleasing from them?
Who did you pay your rent to, Miss Nolan?
To the Drevnos.
Mr. and Mr. Drevno, is that correct? Did she pay you the monthly rent?
Correct.
Okay.
with an extra $100 over what the landlord was charging them.
Was that for the washer and dryer?
No, it's just an extra $100. So I don't know what they applied it to be honest.
I'm curious. What was that money for?
We had all the bills under our name when we left, and so that was to cover those expenses.
Okay, so
We had the gas, we had electric, we had internet. It wasn't until I think last year that she had taken the internet into her own name and used her own card for that. But all the other expenses were under our name.
Ms. Dolan, is that correct? Are the utilities still under their name?
That is correct. And I offered many times to take that from them.
That's totally fine. All right. And then Ms. Nolan, in the text message that I saw and what you told me was that there was a conversation y'all had in person and then again commemorated, at least in this text message here in June, about the washer and dryer. And what I heard you say is that he offered 400 and then he said, I'll break it down to 300 because you've been helpful in getting me packed up. Is that correct?
That is correct.
Okay. And then you did keep the washer and dryer?
It did remain, yes.
Okay. And then he said, do you still want it? And you said, yes, but I don't have the money. And they said, well, we'll add it to the payment. And you wrote, okay, thank you.
Correct.
And then you kept the washer and dryer and kept using them.
Yes, ma'am.
Okay. All right. Judgment for the plaintiff in the amount of $3,800. All right. Good luck to both parties.
I'm sorry. Was I allowed to ask another question?
Go ahead, Ms. Nolan, but I mean, they've met their burden, but yeah, absolutely.
I never not wanted to pay this. And I had definitely planned on paying it by October 24th, but other circumstances, I guess non-related to this, because I don't know how to pursue that. So I guess I need to contact a lawyer about cyberbullying and them upsetting me that I just didn't want to communicate with them at all. When do I need to pay the $3,800 by? And I'll just follow through with my other suit separately.
Well, both parties have the right to appeal my decision. So you have 20 days to do that. If neither party appeals, the judgment becomes final. And then it's really up to the two of you, to the two sides, how y'all go about making compensation or payment or collection. The court doesn't get involved with making the parties whole. We just say if it's owed one way or the other. Okay. All right. And then Brashay, I see you put your hand up. What's up?
Yes, ma'am. So I wanted to get Miss Cynthia, is it Willis? Yeah, Miss Willis, your email address and your phone number. I did send you a message in the chat, so that way you don't have to say it over YouTube. If you could just send it there, that way I can email you
They have that
the
information. I don't
judgment.
mind saying it if you need it now.
Well, no, we don't want you to say it over the
No,
internet.
no.
Oh,
We're
I'm
live
sorry.
on
Oh, that's
YouTube.
right. I apologize.
So I know y'all know each other. We don't. I don't want
one.
you getting some random
Okay, no,
person who's like, I got a
thank you.
washer dryer. Let me show you. You know, who knows?
Okay, I
Right.
understand.
Who knows,
But there's
y'all?
a chat box. I don't know if you're able to see it.
Uh,
It should be towards the bottom.
Quite honestly, I cannot see it.
Don't worry about it. In fact, because
Okay.
we're all done now, if there's no other questions, then